All right, there's two things before the court. One is a child support order that's been provided by Ms. Looney. And then the other is, I believe, a motion for contempt that was filed by Ms. Anschutz. And so why don't we take the child support order information first, and then we'll go to the contempt order. Ms. Looney, do you want to go first?
Thank you, Your Honor. Would you like me to go through the numbers on the order, or would you like just to go from there? I can go through everything. It's how we calculated income.
Well, let me see if we need to. Let me go to the order here. I'm not seeing the box that I'd like to see. Here we go. So this would require Ms. Anschutz to pay $910 a month. Is that right?
Yes, Your Honor, which would break down to $303 and I think 33 cents per child per month.
Ms. Anschutz, any comment on the request for child support?
Yes, Your Honor. I am only working 10 hours a week currently, and there's no way that I can afford to pay that.
Ms. Looney, what are these numbers based on last year's earnings?
Your Honor, we had, at the time of drafting, we had the employment security data for 2022 quarters 1, 2, and 3. Those are the numbers that we based this off of, and we did impute both parents working full-time hours at their current rate of pay at that time, according to 26-19-071. So we do have them at full-time, as we don't have any information stating that neither of them are capable or able to work at full-time hours. We also did request past due support for the TANF period, which was September and October of 2022. We did calculate that at $50 per child per month. So that is set for $300 as the request of the state. So that's what we were basing those numbers off of. And we have a net income for Ms. Anschutz of $26.88 per month, and for Mr. Anschutz of $26.44. Their incomes are fairly comparable.
Your Honor,
Go ahead.
their information, they have me working 40 hours a week at $20 an hour. I was only working part-time last year, and I haven't made $20 an hour in any job that I have. And for the whole September, October charging me child support, I had the kids the majority of the time, and it was still split custody. Like, he didn't have them full time. So I don't understand why I have to pay when I had the kids half the month of September and October.
Have you provided your current earning statements to the Division of Child Support?
I haven't, but I can and am willing to provide it. I've only received like their printouts, and they haven't, that I know, have requested for me to provide those, but I am willing to.
Ms. Looney, I think I'd like you to at least see what Ms. Anschutz provides and see if that makes any difference with the calculation. So if you could provide income information, say going back to last November, let's say November, December, and January. So Ms. Looney can consider that.
Yes, Your Honor, I can.
Okay.
And can we set a review date for this, Your Honor, just to ensure that we get that information in a timely manner so we can take a chance to consider it?
I was thinking of February 15th. Will that be sufficient? Can you get that information? Go ahead.
It may, for service purposes, it may be a little tight. So if we could do the 22nd, just to make sure that we have time to receive the information, consider it. And if we need to send out new proposed orders, that would give us time to serve both parents.
Okay, so let's make it February 22nd.
Thank you.
Okay,
That's on the child support issue.
okay, and then provide the income from November 22 to January 23, right?
Yes.
Okay, thank you.
All right, then next, let me find where we're at here. There was a motion for contempt filed by Ms. Anschutz. And it lists a number of times when Mr. Anschutz both did not take the kids or deliver the kids. And so, Ms. Anschutz, do you want to address your motion for contempt? And then I'll give Mr. Anschutz a chance to respond, and then we'll hear from Ms. Fellows if she wants to weigh in. Okay, go ahead.
Yes, Your Honor. I filed contempt against Ken, one being placing Camden in the Kelso School District after he was already enrolled in Longview, the same school district my older two children have always been and still are. I have proof Camden was enrolled in Longview at Mint Valley Elementary and can provide to the court. Ken broke our parenting plan purposely to hurt me, as he knew I couldn't accommodate transportation to Kelso. No different than all the other controlling behaviors and abuse I dealt with, such as spending the night in the hospital from his past and present violence towards me and the children. I provided all the evidence that is in the guardian ad litem's possession and the courts as well. The children were taken from me because I couldn't get Camden to school in Kelso, which I did not break any laws, as Camden is not legally required to go at the age of 5. Ken, however, did break the law after having an agreement with me and Camden being in and going to school in Longview. Ken broke the law and was rewarded the children. And he also has 21 violations with an extensive violent history, including felonies and prison time, in which the guardian ad litem is aware of and has failed to mention. I asked the court to review Ken's violent history and criminal record today, and that the guardian ad litem has in her possession. I asked that primary custody be awarded to me and the court to recognize with evidence I have provided in court and to the guardian ad litem that the children are being detrimentally harmed, as the judge who reviews my motion to relocate with the children back in September acknowledged and said Ken's actions were that detrimental. Ken also has the older two children write letters, which he submitted into the court, saying they didn't like me and they never want to be with me. Ken also has our children telling the guardian ad litem they want to live with him, although evidence provided showing Ken didn't want to see nor did not take Matthew. I had Matthew for 4 months with no visits between him and Ken. I knew for a fact that there's no way Matthew would say he wants to live with his dad. Matthew's words are out of fear, knowing Ken has put his hands on Matthew, and that I have very recent texts from Ken's girlfriend's sister concerned about child abuse and abuse to his current girlfriend. The guardian ad litem has all this as well. The fact that the guardian ad litem ignored all of this and focused on rewarding an abusive criminal for contempt of parenting concerns me, and I truly believe my children are in direct harm due to the negligence of the guardian ad litem. I ask that Beth Fellows that is assigned to our case be removed, and that the court to review all concerns combined with evidence I have already provided, filed back in September. I would also like to bring up there are 10 declarations submitted into court that were used in the frivolous restraining order back in October that Ken filed against me. That shows the character of Ken and shows I have always been the primary caregiver attending to my children. Ken has failed already at getting the children to doctors and dental appointments, which can be proved. Ken removed Matthew from his ADHD medication against doctor's advice and without discussing it with me, a violation of our parenting plan that was in effect at the time with joint decision-making. Because of this and Ken's actions, Matthew is now failing 3 out of 6 classes. And according to his teachers, he has attention and behavior issues, something Ken does not know as he doesn't attend parent-teacher conferences, something that I've always done. Technically, a 5th contempt of court And lastly, I would like to bring up parental interference during my time, not only on Ken, but his girlfriend as well. On October 26th, Ken's girlfriend called RA Long where Matthew attends, impersonating myself, inquiring on if Matthew was at school, then trying to get his excused absence unexcused. This happening after I had informed school that Matthew was at home ill. I have records showing from school of this. The school had called me out of concern, which is how I found out of the incident. There is also record of me reporting impersonation to the Cowles County Sheriff's Office, as well as Ken's girlfriend admitting in court on November 4th of her impersonating myself. Ken has parental interference during my time with when I have my children, which has been filed as evidence in our case filed back in September. Also, with my original filing in September, I also brought up Ken has had an alcohol problem that also goes along with his criminal violence, and he has been ordered to in the past to complete alcohol treatment that he did not complete. And on Monday this week, I attended Hannah's IEP meeting at school, which Ken did not attend. Like I've mentioned before, Ken has never participated in schooling or appointments before with our children. And Hannah's IEP is very important part of her schooling and extremely important for parents to be involved, in which another reason Ken should not be primary parent. I was also informed on Monday from Hannah's teachers that she was transferring to the Kelso school and that the guardian ad litem was aware of that and encourages when I filed to move with the children she was against due to the children having to change schools when I filed to move back in October. Why is that okay now? When are we going to stop involving my kids in court when we know they are saying things children wouldn't normally say and is being influenced by their dad, which is detrimental to my children's mental health? I should not have been put in this situation. Ken has lied and broke the law, has went against previous parenting plan, and has also deceived a guardian ad litem. He should not be rewarded, and my children and their safety should be the focus and priority. Thank you for your time.
All right, thank you. Mr. Anschutz, do you want to respond?
Yes, I do go to the IEP. I went yesterday. I had talked to Miss Case, and I told her that I needed a separate IEP meeting because I did not want to be in the same room as Melissa. And for Camden and his schooling, I and my fiance went to his class meeting also. And for the kids, Matthew failing school, he actually brought up one of the grades. He was failing before that, something about his mom switched him from Mark Morris to RA Long for his computer class or whatever, and it messed everything up, so his grade had dropped. And for the contempt stuff, we were divorced, finalized, and parenting plan on May 17th. May 8th was Mother's Day. Camden's birthday was the month before in April. And so it wasn't even finalized. Like none of this was even finalized. So I wasn't in contempt of anything at the time. And for Matthew, during the summer, he had a falling out because his cousin was staying here the night, or actually the week with us. And I grounded Matthew because he went fishing when we went out to go get breakfast, and he doesn't know how to swim. So I said he needed to get his butt back in the house. He's grounded. So he ended up calling his mom, and his mom ended up calling her sister. She came over pounding on my door. I called the cops, and she was removed from the premises, but she's not allowed to be on the premises of our townhouse area. And let me see what else I got here. And for my record, I was 19 when I went to prison, and I'm 38 now. And I haven't been in trouble since I was 25. And I have not hit or touched Missy in over 15 years. And when I did do what I did when I was younger, it was due to alcohol, but I have not had any type of problem like that whatsoever. Let's see. I don't think I have anything else to do. You know, I've never put hands on my kids. I don't know where she's getting that information. She was always around, and we lived with her grandma for the 4 years before all this.
There's an allegation that you moved the kids to the Kelso School District without.
Oh, yeah.
discussing it with Ms. Anschutz. Any comment on that?
Yes, I do have on this. So on the text it says I bought all the kids their school stuff, and I said okay. She's like she wrote I got Camden registered for kindergarten drop off. We'll drop off his records the school needs, and she'd be ready to go. And I said what school? Because I didn't know what school she was putting him in because he hadn't been in actual school. She said Mint Valley, and I said how is that going to work? And it wasn't going to work. So she said I had a meet and greet with the teacher. So I went there to go meet and greet this teacher that she supposedly registered my youngest in. I walked in. She said, before we get started, he needs his birth certificate and shot records. And I said, well, my ex-wife said that he was registered here. And she said, no, he's not. He's appointed a teacher, but he is not registered. So I said, what do I do? And she says, well, you need to get his birth certificate and shot records. Well, Missy was in Vegas with her now boyfriend or fiance or whatever he is. And so there's no contacting her. She was gone. So I was like, so can I put him in a different school then? She's like, well, yeah, he's not even registered here. And I was like, okay. So I went to Lexington, talked to them, had all that figured out, went and got his birth certificate from the state office, and went and got a social security number, and went and got a printout of his shot records from LCC from the previous preschool, brought those in, got them all signed up, which Missy failed to have him go to his first week of school, even though she was supposedly living in Longview, which she wasn't at the time. So that's how that carried out, is that she didn't ask me to, or discuss with me about him going to Mint Valley. So I took it, well, she didn't actually register him, so I might as well just register him in something. I had a week until school started, and it was the following week would have been her week. So I was kind of in a panic mode. So I registered him in the school closest to me because I didn't know what she was doing, because she was kind of jumping around guy to guy. So I was like, okay, I don't know if this girl's going to be actually here to take my kids to school. So I did go and register him into Lexington Elementary, where he's been going for the past year, almost a year.
Okay.
Your Honor,
And
I would like to mention, I have a letter from Mint Valley Elementary, and the guardian ad litem is in possession of this, of a letter welcoming Camden to kindergarten, showing that he was enrolled. And also, Ken did not call me, and I did not agree to Camden going to Kelso. I have provided text and evidence filed with the court showing that oh, by the way, Camden is enrolled here. Like, so he's just saying lies, and it's not true.
Your Honor, I'm reading off of the paper that she had submitted. It says right here, I got Camden, her writing, registered in kindergarten, will drop off his records at the school, and we should be ready to go. She did not drop off any of that stuff. And that's when I asked, what school? And she said, Mint Valley. And I said, how is that going to work? I'm just trying to figure out how these are lies if I'm reading the paper that is right in front of me.
Your Honor, I still had time to drop off his birth certificate and his shot records to the school, as it was 2 weeks before school started, and I had plenty of time, and he didn't even give me a chance to do anything. He just told the office that I was told from the secretary at Mint Valley that he had went in there, told the office he had 80% custody of the children, and which was said in August, which that was not true also.
When was it that he registered Camden and Kelso?
He texted me 3 days before school started. School started, I do believe, August 30th. And he had texted me August, I don't have the date in front of me, but it was 3 days before school started, telling me and informing me that Camden was going to Kelso, and did not discuss with me.
All right. I'd like to hear from Ms. Fellows on this, please.
Yes, Your Honor. This case was, there was mom's petition to modify that she did file in September. And it was, she had brought up all of these issues in her petition and the declarations, requesting the adequate cause and relocation. The court, it was in front of you, Your Honor, on September 21st of 2022, regarding the adequate cause. And you basically set it on the trial assignment docket. So the relocation could be set for trial. The trial was set for November 4th of 2022 in front of Judge Evans. This guardian ad litem was present, as well as the parents. The court heard all of these issues that the mother is bringing up and denied her motion to relocate with the children. And that the parenting plan from May of 2022 was to be followed. At that point in time, mom was working in Vancouver, and then from that point on, there were concerns that I had as the guardian ad litem about Camden going to school, and mom not getting him to school. And so that's why I noted it up to bring it back before the court in December, and let the court know what my concerns were, that she was not getting him to school on her weeks, because it's a week on, week off. And then that's why the court then decided, after hearing from both sides and myself, is that the dad was supposed then to be the primary parent. Yes, I do know about the criminal history of the father. I have all the information, as mom has said. But at that point in time, my major issue that I tried to address with the mom prior to the court hearing, letting her know that I was bringing it back before the court, she still didn't get Camden to school in those couple of weeks before the court hearing. I understand that she's frustrated and she's upset and things like that, but this has been heard by the court. And here we are, we're here today.
Your Honor, I also would like to mention that the court dates that were mentioned in the trial that we had, we only reviewed the intent to move with children. We did not bring up the custody issue that I filed for full custody. The trial was only for the intent to move. And I filed for both of those at the same time.
Ms. Fellows, has anything happened since, I think it's December 15th, when I entered an order transferring primary custody to the father? Has anything happened since then that would, where you would recommend a different course at this time?
No, Your Honor, I did do a random drop-in visit at the mother's when the kiddos were there. So I was able to see, you know, what mom's household looks like and things like that. And it was appropriate. I didn't have any concerns about mom's household. But at this point in time, she's still working in Vancouver. I know the court in December had wanted to increase mom's time. However, the issue still remain is that she's working in Vancouver and being able to transport and get the kids to school. That issue still remains. And so at this point in time, I'm not recommending a change in the primary custody. I am recommending that the kids get transferred to Kelso. Since mom is now established in Vancouver, it would make more sense that they get moved to Kelso. They want to be there. The kids have said, and I have not heard anything from them about wanting to change to mom's. And so that's my recommendation. I know that Hannah is extremely anxious to be able to change schools. She wants to start basically, she just doesn't want to be at Mount Solo anymore. She wants to kind of start new and start fresh. So I know that she's really anxious to do that. But I did let Dad know that he needed to hold off until we were back in front of the court for a review before he do that.
Would she go to Cowweeman or
She would go to Huntington.
Huntington?
Your Honor, yes, I work in Vancouver, but my hours, I only work 10 hours a week, and I am able to drop the kids off, pick the kids up, be there when they get out of school. And a lot of what is being said is their dad manipulating the children.
And what I can say to that, Your Honor, is that I have had discussions with the children, both Matthew and Hannah at school, random, neither parent knew that I was going to do that or when I was going to do that. I have had discussions with them at their respective parents' homes as well. And they have maintained the same wants that they want to be with their dad.
All right, on the motion for contempt, what's cited in the motion is are events that occurred on June 1, 2022, September 4, 2022, April 15, 2022, May 8, 2022. And so all of those occurred prior to both the motion to relocate, which was heard in November, and also my order on December 15th, changing primary custody. And as Ms. Fellows has indicated, these issues had been previously brought before the court. And so as to the motion for contempt, I'm going to deny that motion. Secondly, based on Ms. Fellows' recommendation, I'll allow the children to be moved to the Kelso School District in whatever respective school there is. I would like to consider providing more visitation time to Ms. Anschutz. Right now, I believe it's the weekend. Let me just go to my order and confirm what I wrote. Yeah, it's every other weekend from Friday at 7 to Sunday at 5. If that can be expanded, I'd like to consider that. I think we're going to come back on February 22nd on the child support issue. I would like Ms. Anschutz to provide a declaration and a proposal as to how the court can expand her visitation time that we can consider on February 22nd. Provide a copy to Ms. Fellows, provide a copy to Mr. Anschutz. And so that's going to be my decision today.
Okay, thank you, Your Honor.
All right, thank you.
Your Honor, with your decision, I would like to request to change the pickup drop-off location from Longview and be moved to the Woodland Walmart, as it's in the middle between their father and me, and it would be more fair. And I also would like to bring up, as we had split custody for 2022, I would like to claim at least one of the children on taxes for 2022.
Okay, so what was before me today was both the child support and the contempt order. I want those issues put over to the 22nd So the drop off will stay the same until then. If we want a different drop off, I want Mr. Anschutz to have adequate time to respond to that request. And then also to the issue of how the tax exemptions will be handled. Okay. So we'll deal with that on February 22nd.
Your Honor. In the divorce papers, it says for the 2022 taxes is that I claimed all 3 kids, and I already based that off of that because I didn't know that was going to be an issue today, and I've already filed my taxes.
Okay.
Your
Well,
Honor, may I bring up, I looked through our parenting plan and our divorce papers, and I cannot find where it says that. So if he has the proof saying that, I would like to see that.
okay.
Yeah,
So,
page 6 or page 6 of 11. Is that an 8 or 9? 9 down below. It says switch off every year beginning of 2022. Ken claims all 3 children: Matthew, Hannah, and Camden.
all right. Both Anschutz. I'm not going to address this today. We'll address it on the 22nd. Okay. All right.
Good.
Thank you both.
Thank you.
All right. Next is Kenneth Anschutz and Melissa Anschutz. Ms. Anschutz is here.
Yes, Your Honor, and it's Melissa Bigler now.
Just a minute. I think Mr. Anschutz is just now in the waiting room.
I'm here.
Mr.
here.
Anschutz, are you here?
Yes, sir.
Okay, good. All right, I received a declaration from Ms. Anschutz that I reviewed. She expressed concern at the court's prior rulings, but at the end of the declaration, she suggested visits from Friday at 4:30 to Sunday at 7. She would like to change the meeting location to the Woodland Walmart by the Garden Center. And she'd like in order that the parents would make no disparaging remarks about one another in front of the kids. Have I stated that correctly, Ms. Anschutz?
Yes, Your Honor.
Okay. Mr. Anschutz, let me hear from you first, and then I'll hear from Ms. Fellows.
Okay, so the 4:30 p.m. on a Friday wouldn't work due to the fact that my kids don't get off the bus until about 4, and to drive all the way to Woodland at when they would get off the bus about 4:15. 4:15 Woodland, we would make for 4:30 pickup time, and for Sunday at 7 o'clock.
Let's start with: are you willing to go to Woodland Walmart to do the drop off?
I could go to Woodland, yes.
Okay. So what time do you think you could get there on Friday?
What time do you think? 5 something? About 5:30.
Okay. And what about Sunday at 7? That gets you home about 7:30. Would that work for you?
What do you think about Sunday? Oh, my kids, my 5-year-old goes to bed at 7:30, and then my other 2 go to bed at 8:30, right? So
Okay.
I'm trying to think how that would work, because usually when they come home on a Sunday, they get, they take showers and they eat dinner, and then they get all their stuff ready for school for the next day, and then it takes a good amount of time.
Okay,
So,
I get that.
Okay.
Do you have any problem with an order that you're not to make any disparaging remarks about Ms. Anschutz in front of the children?
yeah, I haven't made any of those, but I have no problem with that either.
Your Honor, I've supplied text messages of the way he talks to me, and I've heard from the children of things that he says.
Okay. Let me go to Ms. Fellows. Anything you'd like to contribute?
I think the Friday at 5:30 would be workable because of the kids getting out of school. I did think that the Sunday at 7 o'clock was a little bit late just because of the travel time and stuff like that. So I could see it be at maybe 6 on Sundays. I think meeting at the Woodland Walmart makes absolute sense. It's a midway point and it's right off the freeway. So that really works. I did have an additional idea that any days that the kids are out of school that attaches to mom's weekends, that she be allowed to have the kids those additional days. Like if we just have President's Day, if that would attach to her weekend, then she would have gotten Monday. And then the drop off would be the same as it would be on Sunday, time wise. So that was my thought for a little bit of additional time that wouldn't impact their school or anything else.
Okay. Mr. Anschutz, any comment on that thought?
No, I'm agreeing with Beth.
Okay. And are these Fridays to Sunday, are they every other week?
Yes.
Okay. Okay, let's make those changes then. We'll have, first of all, the meeting location, starting with the next visitation, and I'm not sure when that is, if it's this weekend or the next, will be at the Woodland Walmart by the Garden Center, just to help the parties find each other. I'm going to have it, the delivery at Walmart at 5:30 on Friday because of the work schedule. And then the children will be returned Sunday at 6. If there's a school holiday that is the Monday after the Sunday, which is the mother's visitation, then the mother will be able to keep the children that Monday until 6, and then the drop off will be at Walmart at 6.
I would add also, Your Honor, that if some holidays are on Fridays, that she be allowed the Friday if that's a day off of school as well.
Okay, I'll add that. I'm not sure how many Friday holidays we have, unless Veterans Day is usually on the actual date, but okay.
Your Honor, would it be just like holidays, or would that include school in service days also?
If it's a school holiday, so I was going to add and include the school in service days.
Yep.
With that. So if the kids are not in school on a Monday, or I guess on a Friday where it's your weekend, then you would be able to pick up the children, either drop them off later or pick them up a bit earlier. Okay. And it is important to the court that there are no disparaging remarks that they make in front of the children. I think one of the most difficult things we deal with is where parents, through comments, poison the children against each other. I don't want that to happen in your case. If it has been going on, it needs to stop right now. And I don't expect it to continue. If there's evidence that there are disparaging remarks made after today to the children, then there will be a sanction for that. It could be loss of time with the children, could be a monetary sanction, but there will be a sanction. So I just want the parties to understand that. Okay. So I'm going to enter a bench order to this effect. If you want a copy of that, I'll be ready in a couple of days. Yeah. All right. Thank you.
Your Honor, we're also here for child support today.
I'm sorry if both parties could remain. We do have a child support And have the parties looked at the Office of Child Support work documents?
Yes, and I returned it to them.
We did receive the
Any
signed signature page from
objection?
Mr.
Oh,
Anschutz.
excuse me, go ahead, Ms. Lee.
Sorry, we did receive, Mr. Anschutz had signed that he agreed, so we did receive that.
Okay. All right, well, if we're in agreement, then I will go ahead and sign those orders.
Your Honor, the papers that I received from child support, they have me working 35 hours a week. I only work 10 hours a week, and medically I'm not able to work more hours than I currently do to women issues. I'm set to have surgery in the next 3 to 5 months with the date to be determined. And when I do have surgery, I can't work for a minimum of 8 weeks. And I know in the papers, it did say something about my previous job. I only worked 22 hours a week there and made $1 more, but that was a COVID job and it no longer exists, hence to why I transferred to a new job. So I just wanted to bring that up because I don't work 35 hours a week. I can't pay the full of what they're asking at 10 hours a week at $17 an hour.
Ms. Looney, do those comments result in you needing to maybe go back and look at the amounts again?
No, Your Honor. We have imputed Ms. Anschutz at full-time for her current rate of pay. She did provide the pay stub showing her current rate of pay. Previously, she had disputed the hourly wage that we had imputed her at. We believe that she is voluntarily underemployed at this time. And we have no record regarding medical conditions. And at this time, it sounds like that's a temporary condition. We don't set our orders based on a couple of months of inability to work. We're looking at long-term when we're setting child support orders in place. So under RCW 2619-071, subparagraph 6, we believe that imputation under the statute is appropriate at this time, and that we would be requesting the $757 transfer payment for Ms. Anschutz.
Ms. Anschutz, what the statutes direct Ms. Looney to do is to impute income based on up to 35 hours a week, which is what they've done. So these worksheets in the child support order comply with the statute, and there's actually not much discretion the court has to deviate from that. So based on that, I'm going to go ahead and sign these.
Your Honor, there's no way I can pay $700 and whatever they're asking a month. And I literally cannot work full time, and it's more than a couple of months. The surgery is going to be 3 to 5 months. I'm still waiting on insurance and a date. And then I'm on state assistance. I receive food stamps. I receive state medical. There's absolutely no way I can pay that a month on 10 hours a week. That is, I literally can only work that right now. And I can provide my medical if needed.
When you go out and cannot work, would you provide that documentation to Ms. Looney, and she can take that into account at that point in time?
Your Honor, she can connect with the support enforcement officer that would be involved in the case and discuss with them if she needs to have a temporary reduction in the amounts that she's paying. But we would not be looking at changing the amount of the transfer payment that we're requesting. She would be accruing arrears, but they could temporarily allow her to pay a lower amount while she's recovering from her surgery.
And could she contact your office to learn the name of the support enforcement officer?
Yes, Your Honor, we can give her that information.
Okay, what about right now? Like, how am I supposed to come up with $700 some that I don't have?
Again, the statutes lay out what these amounts are, and the court has very little discretion to deviate from that. So I've entered this order, and that will be in effect. Thank you.
Thank you, Your Honor.
Elizabeth Muro and Rigoberto Montez. I know I've seen Mr. Montez here.
Good morning, Your Honor.
Good morning. Is Elizabeth Muro here?
I don't know. I saw her this morning.
I'm
she-
here.
Oh, there she is. Okay, good.
I'm working. I'm at home sick, so I don't don't know how to use it on my phone. Normally I use my work computer.
All right, let me ask a quick question. You were in front of Judge Basher within the last couple weeks, I believe. And that was for a trial setting. And he indicated